Welcome back to part 6. You're here with Philip Bickle of Legal Tyranny. This is the argument section, and you're going to find out how dense this stuff gets and why a lot of time has to be put into it just going through this section. So I'll probably have to create a separate video after I'm done reading through the entire brief so that you guys have the entire brief to consider. And if you feel like it, you can start doing searches on a bunch of the things that I discuss and the codes that I cite. So, for instance, like this section right here is involved with an arrest, and it's a good bit of text in the book. It's about this much text minimum. So there's a lot of details, and then these rules, some of them are quite lengthy, but they're the words that are used are critical because in these sections it indicates what the government is supposed to do, and in most cases the terms they use are shall, and shall is for a mandatory act or abstaining from something. If the word shall is used, if the word may is used, it's permissive, and that's the sort of thing where like a cop has discretion. But this will get really dense, so you have to decide that this is really something you want to spend some time learning. All right, so starting at the top, we've got an introduction. You always want to have an introduction, just a couple of sentences describing in general what the theme is going to be for the arguments. In my case, it's an issue of failure to follow process and judicial prejudice and biases. All right, Part B. Defendant-Appellant was not charged within the statute of limitations. Therefore, the alleged offenses were time-barred. Both defense exhibits C and D show that I was issued a citation in lieu of physical arrest pursuant to Section 803-6B of the Hawaii Revised Statutes, and summoned to be orally charged as authorized by Rule 7A of these rules. The charges in question: one count of driving a motor vehicle without a driver's license, HRS 286-102, and one count no motor vehicle insurance policy, HRS 431-10C-104, are both petty misdemeanors. The official transcript of the December 15, 2016 hearing shows that at no point in time did Prosecutor Evan Smith enter oral charges as required by Hawaii Rules of Penal Procedure 5B1 and B2 and Rule 7A. The prosecution failed to orally charge me. The record on appeal also shows that no written charges were ever entered. The ROA docket shows that on January 4th, 2018 and March 1st, 2019, the prosecution entered oral charges. The official transcripts for both of these dates show that I entered objections to the entry of charges on the grounds that the statute of limitations had expired for both alleged offenses. Okay, so there's a whole bunch of sites here, and this is the sort of thing that they should be able to help you with. Again, these were reasonable objections. It's well-established law. The statute of limitations is very, very well-established law. So, that's why I got ignored when I entered my objections, because they knew I had them, and they absolutely did not want this defiant young man to walk away from the courthouse with a win. And I don't know. I still think my name might be floating around out there after suing a judge in L.A. when she tried to get me to plead to not being charged. And that's the case that I put videos up where the prosecutor decided not to charge me. I actually went into court with that paper, and this Judge Sanchez, still made me come in for a total of 4 appearances. And it wasn't until the end of the third when she realized, yeah, this guy's a problem. He's a headache. Let's delay this for a week while I figure out what I'm going to dismiss this over. So, yeah, I wouldn't doubt if they got me on their radar. And there's other people like me. I'm not the only one. It's just, publicizing this stuff, trying to get it out there so the public will recognize just how rotten the court system is. Okay, so back to this. Enough with the tangent. Okay, this document right here is going to be a really good one. You guys are definitely going to want to subscribe so that you can see what I put in here. This was very, very well researched. Okay, by trade, I was a research scientist, and I was actually going to be tasked for setting up the revamping the experimental section in the Sacramento State Behavioral Science program. I'd been tapped for that, but my body gave out. Like, I've got way too many health issues. I shouldn't have even been in a school, but I was trying to do something else with myself. So I know how to research things. I'm really, I'm very, very good at breaking things down and avoiding traps and things that are thrown out to distract people. But keep your eyes, if you're subscribed, keep your eyes open for this one. Written argument for trial. I think I'll do that immediately after this one because it has stuff people can use right now in all sorts of different types of cases. And it's just nailing them on procedural violations that they do as a matter of habit. They're just used to people coming in, bending over, and taking it raw. That's it. So, you go in there with the sort of knowledge that I've put in these things, and they're going to recognize, you have to study it too. You just can't study my stuff. You have to take my stuff and look a little, research a little deeper so you're familiar with the topic. You do anything else, they'll think, that they can walk all over you because you're not going to be able to deal with when they change topics up on you and you're not familiar with some other similar related topic. All right, let's see. In my written argument for trial, ROA docket 107, pages 3 through 6 contain argument laying out the laws governing the statute of limitations for the alleged offenses. The prosecution never entered any facts showing that they had entered charges within the statute of limitations. Absent this evidence, I was supposed to be found innocent as required by HRS 701-114-2 and 701-114 subsection 1 subsection E. So it'd be 114-1E. After entering my objection to the charges on the grounds of them being time-barred, Prosecutor Downs claimed that the citations were prosecutions initiated by complaint, as they would say so. Like they who? Let's see. So this is where the judge jumps in to do a little dancing with his partner to get out of this mess, being caught on that. Judge Freitas concluded that, according to Rule 7, the complaint is a citation when issued by an officer. The Rule 7 of Hawaii Revised Rules of Penal Procedure. And then, as far as your statute of limitations, your matter, I agree, your matters commence from the date that your citations were issued. And we've been coming to court for the last several years trying to get through this. The citations, or I should say, statute of limitations, does not say when it must conclude. It just says when it must commence. And I'm going to find that both of them commenced from the day of these citations being issued, and we've been proceeding through these ever since then. So I'm going to deny both motions at this point. Oh, that was for the statute of limitations. Also, under Rule 7 of the Hawaii Rules of Penal Procedure, amendments may be made anytime prior to trial. Okay, you want to enter your pleas at this point, Mr. Bickle? Or you want me to enter it for you? Yeah, it's a big screw you, Mr. Bickle. I'm going to let this go forward, even though the code clearly spells that he couldn't. All right. As I laid forth in my motion to dismiss and in my written argument for trial, the enforcement officer, aka police officer, is not a prosecuting officer and is not authorized to commence prosecution. I incorporate these points and authorities in this appeal as cited here. That's the record on appeal docket number 6. The very first motion I ever filed relating to the traffic criminal matter was in the Hilo District Court, and that's the motion to dismiss for lack of all jurisdiction. That's, Judge Udovich claimed he read it, and then during the proceeding, I asked him if he was familiar with certain letters that I had mailed off and not gotten any response from the DA on. And he tacitly agreed to some stuff in there, including the fact that they hadn't commenced prosecution. So, yeah, that motion to dismiss wasn't read by that judge because he wasn't familiar with 2 letters that were stapled to the very back of that motion to dismiss, and the motion to dismiss had 15 points. That's 15 paragraphs numbered, and out of that total 15, 1/3 of the paragraphs referenced the 2 letters stapled to the back of that brief. And this guy didn't know about the letters. So he obviously didn't read it, and he dismissed it. So there were points in that, and I'll have to put this motion. Let's see, did I put that up already? I think I may have put. Yeah, I'm so sleep deprived I can't even remember. Okay, I'm pretty sure this one's actually up, so you guys could go watch that. It's like an hour long. My first time reading one of these things out. I'm just trying to figure out kind of a format to go with here, especially with the sleep deprivation, losing train of thought at times. Let's see, I got 6 hours sleep last night, 5 the night before. It grinds on you. Okay, so that's good. All right, so I wanted to have a few points actually spelled out in the appeal here, so that these judges can't treat me the way that Udovich did. And if they happen to read this one, but they don't actually take the time to go and read my motion to dismiss, I took what I felt were a couple of the most powerful points that they just can't ignore, and I put them in here. And it keeps the motion from being too long, because you're usually page limited on how much, you can bring up. So try to be succinct. I will reiterate a few points with authorities mentioned in the aforementioned filings. The power of the Attorney General has been extended to the county prosecutors, and the following law supports this argument. Criminal cases, prosecution by county prosecuting officers under authority of Attorney General. And there are multiple case sites here. This is well-established law. It's actually listed in, I think it's Hawaii Revised Statute 28-2. It actually states that's their job, to prosecute, and they're all underneath the Attorney General. It describes that right there in that statute if you want to look that one up. So yeah, you could also put as a, so let's see, State v. Radcliffe. The prosecuting attorney has broad discretion to initiate criminal proceedings to to decide when charges will be filed, what charges will be filed, how many charges will be filed, under what statutes the charges will be made, and when the proceedings will end. So when you get a traffic ticket and the cop has certain things checked off, he's not the one that actually gets to decide finally what the charges will be. The prosecuting attorney's office is supposed to take some time, look into what allegedly happened, see if there's enough evidence, and then they decide evidence of which certain things may have been violated. And they'll put together a case. They're supposed to file a verified complaint and serve that upon the alleged defendant. Courts are skipping this entire process. Okay, the Hawaii Rules of Penal Procedure Rule 7 does not match up with Judge Freitas' conclusion that, according to Rule 7, the complaint is a citation when issued by an officer. The relevant section, Hawaii Rules of Penal Procedure Rule 7A, states, this is the section, look this up, there are codes online, you can actually look this up. Do search for Hawaii state statutes, and you should be taken to a web page that'll let you select to get into the HRS area. The charge against the defendant is an indictment, a superseding indictment, an information, or a complaint filed in court, provided that in any case where a defendant is accused of an offense that is subject to a maximum sentence of less than 6 months in prison and is issued a citation in lieu of physical arrest pursuant to Section 803-6B of the Hawaii Revised Statutes and summoned to appear in court, the citation and an oral recitation of the essential facts constituting the offense charged as set forth in Rule 5B1 shall be deemed a complaint. Okay, so Judge Freitas indicated that it's a citation when it's issued by an officer, but there's one additional thing required before it can be considered to be a complaint. And a complaint is what they can move forward on to try to have you enter some sort of plea, but the complaint has to be entered in the form of charges by a prosecutor. That's a key step there, and they're not doing it. Usually because it requires like quite a bit of detail and writing up the description of what you're alleged to have done, and then they also have to put on presentation of the evidence. And if you know how to do certain things in court, the whole process just slows things down for them, and they won't be able to stick their hand in as many pockets. Okay, so this section that I bolded, that's a critical section. I don't care what state you're from. If you're trying to learn this stuff, just go study the stuff that I'm putting up for Hawaii. You will be, by the time you're done getting familiar with this stuff and where they're performing the systemic deprivations of due process, you'll be able to come back to your home state. And in fact, you could probably parallel it as you're learning from what I'm putting up here in Hawaii and what I've posted actually with my California research. You'll understand how to navigate the books and the sort of nature of things, what they're looking for to have proceedings occur fair and lawfully. Okay, let's move on from there. Hopefully the AC isn't making this too noisy. Oh yeah. Okay, so this other section, this is incredibly important. All right, so earlier in one of the prior videos, I mentioned about how there are people that tell you never waive anything. They're wrong. They don't understand strategy and they don't understand tactics. And you can take advantage of this under certain contexts. you have to go back through my videos because I don't know which video I discussed that in. Might be about the third one, maybe the fourth one. But you know, this issue right here, if they're going to be lazy about doing their jobs, and I mean, really, their jobs primarily consist of harassing mostly law-abiding citizens. They have, you know, certain behaviors have become things that they think they can kill you over in the long run. It's entirely reasonable to make sure that you've studied the rules well. And if you know the rules in and out, you can see where waiving something would benefit you. Again, quick example, statute of limitations. If that runs up and you waive something and they haven't performed certain required things before they try you, then they don't get the opportunity to go back and enter charges again because they passed the statute of limitations. Like, this is all stuff that should hold up. It's their rules. It's their rules. And so, you know, if you study this and you see that they're not following it, then do like me, put videos up showing it, because the public needs to see just how corrupt these courts are. It's, you know, this stuff, like, just about anybody could do this if they have a high school education. You just have to be willing to read. All right, let's move on. Enough of a rant. We're almost done. Let's knock this out. All right, the citation must be accompanied by an oral recitation of the essential facts constituting the offense charged. Those two things together are deemed the complaint. Furthermore, Judge Freitas erred when he concluded that the prosecution met the statute of limitations requirement by finding that prosecution commenced on the date the citations were issued. The unpublished decision in State v. Cantaberos lays out the requirements of the prosecution to enter written or oral charges within the statute of limitations. The citation filed with the court by the officer is constitutionally insufficient and fatally defective. Let's see. The citation fails to allege all of the essential elements of the offenses alleged. The oral record contained in documents for my other appeal, transcript of the proceedings for this other case at the district court level. It shows that Judge Freitas admits to relying upon charges entered well beyond the statute of limitations for all of the alleged offenses. We'll wrap this up right here. So, if you like so far, then please thumbs up, subscribe, share this, and when I come back, I'm going to go over where I locked the judge into which alleged charges he was going to rely on. And this is important because that applies to the statute of limitations. All right, thank you. Till next time.